we invite the BCFOWA President, Mr. Srinivas, online.
Good evening, everyone. This is the session agenda. As you are aware of the present topic of discussion, that is the property tax for apartments and complexes which are in Karnataka. So this is a hot topic for everyone today. And in this connection, so we have our founder member, Mr. Anil Kalgi, who is the what you call catalyst for this entire event of forming this BCFWA. Today it is taken to a shape, and we are all benefiting through that particular organization. So far we have got so much of knowledge from BCFWA to enrich ourselves to fight our illegalities or unregistered things and fight for our rights. So I would like to introduce Mr. Anil Kalgi in this case, actually, because he is the subject matter expert in many areas concerned to the homeowners is concerned. And he, under his stewardship, we have taken a case of Section 5 COPA. So High Court has given a order to implement this COPA Section 5 connected with the home buyers and builders. Then we are also fighting for the DOD registration by the state, so which is under the with the High Court. The outcome is yet to see. And he is the RTA activist, and then he is a law student from Vivekananda College of Bangalore. So I would like to invite Mr. Kalgi to throw the knowledge on this property tax for apartment complexes and enrich, and then take us to the new area which we are not aware of today. I would like to invite Mr. Kalgi to take up the session.
Good evening, everybody. Am I audible? Okay, many a time we claim that we are paying property tax for individual apartment and everything. Again, we comment and we say that the local bodies are not providing a service regarding garbage disposal. So many parameters that exist. Then the one question comes invariably is property when I call. So first and foremost thing that each and every one of us need to know is what is property first. Then the question comes is what is property tax. So to go through, I just would like to give you the basic information about these things. Then we will arrive what has to be done and what is our liabilities. Now let's understand the property tax for the apartment when I'm talking about. To understand, basically, these are the things that we are going to discuss. That is, what is immovable property for which tax we pay, apartment, an individual dwelling unit, and so many things. So we'll come back one by one. So let us understand first, what is immovable property? Basically, the issue comes is the definitions are many and they are not exhaustive and it do not cover completely. So to start with, it comes with under the General Clauses Act of 1897, according to Section 3, subsection 26 of General Clause Act. Immovable property include land, benefit to arise out of land, and things attached to earth, or permanently fastened to anything attached to the earth. This is what is the word used for immovable property. Now again, similarly, subsection 6 of Section 2 of Indian Registration Act of 1908 defines the term immovable property as immovable property which include land, buildings, hereditary allowances, right to ways, lights, ferries, fisheries, or any other benefit to arise out of land, and things attached to earth or permanently fastened to. Now what comes again the next immovable property? See, when we talk about the Transfer of Property Act, here he directly do not define the immovable property, but he only says that what cannot be done with immovable property. The definition comes something like this here. Immovable property does not include standing timber, growing crops and grass, etc. Attached to earth means rooted in the earth, as in case of trees and shrubs, imbibed in the earth, as in case of walls or buildings, or attached to what is imbibed for a permanent beneficial enjoyment of that to which it is attached. So in general, when we derive at the three different definitions that is coming here, so the immovable property, we can conclude that with this definition, the land and buildings are immovable property, nothing other than that. Now the question comes, apartment is an individual dwelling unit in a complex. Do you all agree with me this? So apartment is an individual dwelling unit in a complex. Apartment in a complex comes with the following essential conditions. Restricted usage and common usage are the two parameters. So apartment is an individual apartment is exclusively for individual usage. Car parking is restricted to individual. Some of the designated facilities are also for individual. That means it cannot be used by others. Same manner, the apartment is an individual dwelling unit in a complex, comes with the common facilities that are basement, approach road, lift, lobby, corridor, clubhouse, and many other parameters that comes. Usually the apartments are sold with a specific living area with a distinctive undivided share in the scheduled property. Schedule A property is a piece of land on which the complex is constructed. This amounts to living area is built on an undivided share of land with a restricted usage. Now here comes the issue. According to the section 6D of Transfer of Property Act, an interest in the property is restricted in its enjoyment to the owner personally and cannot be transferred by him. So that means undivided share, when we talk about, it cannot be transferred and it cannot be sold to the new person. This clause states that a person cannot transfer anything which is an interest restricted in its enjoyment to him. You'll all agree that every apartment comes with that only for my usage, correct? Same manner, it cannot be, it is restricted in its enjoyment, cannot be transferred. For example, of course, earlier this stage was there, it has been clubbed like this. Two brothers partition of property among themselves and in addition give a right of preemption, which means one of them, if at all wants to sell the property, should first offer to the other brother who would preferential in buying it. Here it should be known that these rights are personal right and cannot be transferred. So in the apartment also it happens in the same way, if that is the case. So all these definitions now under the General Clause Act, under the Registration Act, under the Transfer of Property Act and the restriction therein, all these definitions do not recognize an individual apartment in a complex as a property which is heritable and transferable. But however, there is a facilities available under the Transfer of Property Act which has to be dealt, which are dealt under section 45, 46 and 47 of Transfer of Property Act. If the property is in joint tenancy with a distinctive interest, such a distinctive interest will accommodate the essential condition of the apartment and such share will be heritable and transferable, provided the entire property is transferred as a joint tenancy or a joint ownership property. The essential requirement to accept an individual apartment as a property is the entire property has to be a joint tenancy or tenancy in common with a distinctive interest. This is where, in fact, we should understand the regulatory laws makes it very clear. We, the apartment owner, many times, many ways, the people say that this law is not applicable, that law is not applicable. But now, if we understand the definition of immovable property and the restrictions therein it is available, now this is where the regulatory laws makes it very compulsory so that to give an effect of section 45, 46 and 47 of Transfer of Property Act, wherein you can have your individual portion heritable and transferable. Coming to the point here, let us go back and understand Karnataka Ownership Flat Act, that is KOFA 1972. Section 11 makes it very clear. Promoter to convey the title, etc., and to execute the document according to the agreement. The promoter shall take all necessary steps to complete his title and convey to the organization of person who takes the flat, which is registered either a cooperative society or as a company aforesaid, or to an association of flat taker, his right, title and interest in the land and the building, and execute all relevant documents. Therefore, in accordance with the agreement executed under section 4, and if no period for execution of the conveyance is agreed upon, he shall execute the conveyance within a prescribed period and also deliver all document of the title relating to the property which may be in his possession or power. Now, this is what KOFA Karnataka Ownership Flat Act talks about. Now, many people say in different way. Now, let us understand the RERA. Now, section 17 of RERA makes here again very clear. Section 17(1), the promoter shall execute a registered conveyance deed in favor of the allottee, that is the individual apartment, along with the undivided proportionate interest in the title in the common areas, undivided proportionate title in the common area to the association of allottees or to the competent authority as the case may be, and hand over the physical possession of the plot, apartment or building as the case may be to the allottees and the common area to the association of allottees or to the competent authority as the case may be in real estate project, and other title document pertaining thereto within a specified period as per the sanction plan as provided under the local laws. Now here the word is used is common area and association of allottees. Provided that in absence of a local laws, the conveyance deed in favor of the allottee or the association of allottees or the competent authority as the case may be under this section shall be carried out by the promoter within 3 months from the date of issue of occupancy certificate. Now, RERA defines section 2(n), that is common area. Common area means the entire land of the real estate project or where the project is developed in phases, and registration under this act is sought for phase or the entire land of that phase. Now there are many more things that comes common area means, but here if we understand this particular section, that is section 2(ni), the entire line itself is a project where we are referring here. It need to be conveyed. The compliance to the regulatory law gives a perfect title to the individual apartment in a complex. So whether it is RERA or KOFA, Both are making very clearly that the entire property here, it is getting converted into a joint ownership, thereby the tenancy in common is achieved. But when it comes to, but in Karnataka as of date, we find that UDS is sold, but the entire property is not transferred as a joint tenancy. The entire property is not at all converted into a joint property. When the property is not transferred as a joint tenancy, individual apartment cannot be termed as a property. Here the question comes is, you are a possession holder. Undivided share in the property is being declared, but the property is not converted into a joint property. So hence, it cannot be called the portion of your building as a heritable and transferable. But the entire land and the building is a property. Now, we should understand the entire land, building, which is called as a property and is owned by the promoter or the builder. An apartment owner is just a UDS holder or a possession holder of such living space. So in this case, can we call apartment without following the regulatory laws? Can we call it a property? The Transfer of Property Act, Section 6, the Transfer of Property Act do not recognize as of now the individual apartment in a complex as the property. As the definition we have understood earlier, it makes it very clear. The land is a property, building is a property, but the portion of the building which we live in is not termed as a property, but it is an enjoyment that we do it unless or until the property is converted into a joint tenancy. We cannot call the entire property as a ownership property by you. So here comes property tax, means tax on immovable property levied by the local body every year. Every such property owner is obligated to pay, failing which local body is empowered to create a charge on the said property. Then who is liable to pay the property tax? Primarily, the responsibility of the payment of property tax in India is the owner of the property. Talking about the property here, please understand that today's practice as of now, we are only the undivided shareholders. It is not yet converted into a joint property and a joint tenancy, it has not appeared. So hence, we are not at the owner. We are only the, along with the builder we are. So when the builder has not converted into a joint property, to call it I am a owner, so the ownership of the property, that is land and the building, is vested with the promoter. So when it changes, this is where the COFA section 11 and section 17 of RERA makes it mandatory for the promoter to convey the title to the organization of the apartment owners. Until the obligatory laws are followed, the property is not transferred to the apartment owners. This is where the regulatory laws also makes it very clear that, well, what it makes clear? Section 6 of Karnataka Ownership Flat Act makes very clear, till he conveys the property, that is land and the building, the responsibility of the outgoing till the property is transferred. A promoter shall, while he is in possession and where he collects from the person who have taken over the flat or taken the flat of sum of payment of outgoing even thereafter, pay all outgoings, including ground rent, municipal and other local taxes, taxes on income, water charges, electricity charges, revenue assessment, interest on any mortgage and other encumbrance, if any, until it transfers the property or the flat or to the organization of such persons. Well, here also the Karnataka Ownership Flat Act makes it very clear until he conveys the title. It is the responsibility of the promoter to maintain, as we are all undivided shareholder, the accountability is still vested with the owner, that is the landowner or the builder as such. Again, when it comes to that is COFA, but even the Karnataka RERA also makes it very clear. Section 11(4)(g) makes it very clear here also. All outgoing, pay all outgoings until it transfers the physical possession of the real estate project to the allottee or the association of allottees. Please understand here both these two sections, section 11 and section 11(4)(g) of COFA and RERA, is to obtain a proper ownership of the building. Until this is achieved, it is a responsibility that remains. They are giving it on the builder or the promoter, as the case may be, which he has collected from the allottees for the payment of outgoing, including land cost, ground rent, municipal or any other local taxes, charges, water, electricity, maintenance charge, including mortgage on the mortgages or other encumbrance, such other liability payable to the competent authorities, bank, financial institute, which are related to the project. What it is telling here, till the section 17 of RERA, he is obligated to do it. So he is obligated to pay himself. Now let us understand how the taxes of the properties are calculated. So we have understood here who is liable to pay the property tax. We have understood what the property is. We also understood who is liable to pay the tax. So now let us understand how the property tax is calculated. Here, Karnataka Municipal Corporation Act of 1976, section 108 2B, it defines a taxable property as a residential building and building other than commercial building as such a percentage not being 0.3%. Now, please understand the word here they have used: residential building, commercial building, and so and so. The taxable capital value of the building shall be assessed together with the land occupied on it. The taxable capital value of such land shall be assessed having regard to the market value guidelines of the properties published under section 45B of Karnataka Stamp Act. Subject to such rule may be prescribed, the taxable capital value of the building shall be equivalent to 50% of the market value guidelines for the properties published under section 45B of Karnataka Stamp Act minus the depreciation at the time of assessment determined as far as the government from time to time. Now, please understand in both regards, section 1 and 109 of KMC Act makes it very clear the local body can charge tax on building. Please underline my word here. Please understand very clearly. They can only levy the tax on the building. The property tax is levied on by percentage, varying from 0.3% to 1% of a guidance value decided by the state time to time. But practice is on the built-up area of the building. The computation of the property tax is done by multiplying the unit of the property per square feet tax rate per month, that is called as unit, that is fixed on the basis of the location of the property and multiplied by the current property tax rate. But what are we finding out? But property tax is collected from the individual apartment is on the super built area. Every one of you will agree. It is being charged on super built area with a tax per month, that is of the property and multiplied by the current tax rate. Here there is no definition is available called a super built area. Again, we find that there is no difference in tax structure between apartment and individual house. The zone-wise rates are different. So here, why are we talking about this is, please understand, by understanding here 108 and 109 section of Karnataka Municipal Corporation Act, they are empowered to collect tax, property tax on the land and the building constructed on the land, including the land, they can able to collect. Dear friends, we are all apartment owners. Whether the apartment fall under section 108 and 109 of KMC Act, the answer remains here is no. Because the question comes is, individual apartment is a portion of the building, and portion of the building is not on its own a building. It's a portion of the building. It's not a building on its own. And the land is undivided and it is not yet conveyed. The owner is somebody else. So when all the parameters are not defined or explicitly given a power to the local body, they cannot charge a tax to the individual apartment. They can only collect the tax from the building that is so constructed. The building people can able to divide among, depending upon their interest in the property, they can divide their tax. But there is no provision under the KMC Act or any other law to make it a portion of the building as a taxable. And I have not come across, we have made enough effort from the government as well as from the local bodies, on what basis they are giving, how are they calling it. So far nobody has answered. And this is also the reason local bodies cannot force you to pay the tax. So to understand the KHATA and many things, we should understand KHATA is for what? KHATA is for a piece of land for which there should be a specific schedule. What is schedule? Schedule is a chakbandi, the other word that we use. That is north to east, east to west. Proper identification is being given, north to south and east to west. The specific parameters have been given. Then what all existing, north, south, east, west, all the things will be defined for which the KHATA is being created. KHATA can also be amalgamated or it can be bifurcated. When there is a specific schedule is available, a schedule can be divided or schedule can be merged with a subsequent or adjacent schedule along with this property. So merging with the adjacent schedule is called as amalgamation, and dividing the property is called as bifurcation. Now let us understand all these things. Apartment, there is no chance for bifurcation because it is undivided interest we are having, undivided shares. So again, looking into the KHATA parameters, an individual apartment on its own do not have a specific schedule. Same manner, there is no proper piece of land is available. So the KHATA making is not at all permitted under the law. Apartment complex may be constructed or bifurcated land or a KHATA on which KHATA is done. Now, by understanding section 108 of KMC Act and 109 of KMC Act, then by understanding what is the immovable property through the General Clause Act, through the Registration Act, through the Transfer of Property Act, which are all talking about the land and the building, nothing more than that. Apartment on its own is not a building. Apartment complex is constructed on a specific land, and such complex will have KHATA. One complex will have one KHATA. Individual houses, one complex will have one KHATA. Can a multiple khatas can be given in a complex when a specific schedule is not available, the land is not available, they cannot able to issue. The law is not permitting local bodies to give khata for such building, but however it is practiced. This is where we are being practiced. Promoters are not following the regulatory law, that is making it a joint property, and conveyance is not happening. Conveyance of the title is not happening. When a joint conveyance is not happening, obviously the entire apartment cannot be called as the property on its own, because as it is, the General Clauses Act, Registration Act, and Transfer of Property Act and Section 6 of Transfer of Property Act prohibits sale of such property. So given a situation, it cannot be called as a property and it cannot be alienated. So then who is liable to pay the tax now? Unless or until the properly it has been followed, here the regulatory laws plays a vital role. That is Karnataka Ownership Flat Act Section 11 and Section 17 of RERA. Unless or until the building cannot be called as a property, your apartment cannot be called as a property, you are just a possession holder until such a joint conveyance is obtained by all of you. So unless or until it becomes a joint property with common tenancy in common, this cannot be called as a property. Okay, now what are the challenges that apartment taxpayers we are facing? Now let us understand the fact over here. When an individual house is available, individual house will get all the civic services like garbage lifting, street light, street cleaning, or a gutter cleaning, etc., and so many things. Such civic services are not available to the apartment owners, but we are paying all those taxes to them. In many cases, some of the infrastructure or also tax are levied separately. In the apartment when it comes, they also charge separate taxes like clubhouse, gym, indoor games, and many other things. Individual apartment complex, in a complex is a portion of the building with a UDS. By virtue of the UDS, individual apartment cannot enjoy the independent khata or a sub khata. When this is the case, but when you compare the tax payment that we are doing, it is more or less, it is more than what we are paying in an individual house. Tax to be calculated on a built-up area of the building. There are no separate calculation method for calculating tax for individual apartment and collect such tax. Here again, I would like to emphasize upon all of you to understand, tax has to be collected on the built-up area of the building. There is no separate calculation method is available to calculate tax from individual apartment and collect such tax. The government, the law has not given them any power to divide it, subdivide it, and do whatsoever it is. They can only collect from the building, and the tax can be levied on the building and the land on the land and the building. They cannot do anything. So Section 108 and 109 of KMC Act makes clear tax levying has to be on the building, not for or from the portion of the building, wherein individual apartment in a complex are portion of the building. So with these parameters, if we observe today how we have been practiced, that is number one. We are all apartment owners. We call ourselves, we are the apartment owners with undivided interest in the undivided share of land. the undivided share of the land is not conveyed. So our built up land or a super built up land, which the built up area we are living in, or we are in a possession holder of such living area. And when the property is converted, it is not converted into joint property, it cannot be called myself become a liable for anything, and it is not a property, but I'm a possession holder. The regulatory laws also makes it very clear in all the manner. Even the Transfer of Property Act, how it gives the effect is the entire property has to be a joint property. Then the property has to be a joint conveyance, tenancy in common with a distinctive interest. When the property becomes joint property, tenancy in common with a distinctive interest, such a distinctive interest which has got restrictions, so many things what we are practicing in apartment now, and if that is being done, then the entire building becomes a property, and by the virtue of the building being a property, my apartment becomes heritable and transferable as a portion of the property because I'm an interest holder with a specific interest. So the essential requirement for an apartment to be called as a property is the entire building and the land on which the building is constructed has to be a joint property with the tenancy in common. I hope I'm communicating to all of you. Tenancy in common. So such a tenancy in common becomes heritable and transferable, and the entire building becomes a property on its own. Until then, it's a property, but it is owned and managed by the builder. If at all, the entire property belongs to the promoter. Even though I'm having an undivided share of land in the entire land, not on the building. Now, even though I'm having an undivided share of land, but it is not explicitly transferred. When it is not explicitly transferred, the ownership of the property continues to be with the builder. When it is continues to be remain with the builder, the payment of tax to the local body is by the owner of the property. Here, the builder continues to be the owner. The individual apartment owners are just the UDS holder. In general, in apartment is a portion of the land with UDS. By virtue of the UDS, individual apartment cannot enjoy the independent KHATA or a sub-KHATA officially. Officially, ownership continues to be with the promoter until the joint conveyance of the property, that is land and the building, for the joint tenancy. The current trend of sale of apartment do not make an individual apartment as an heritable and transferable. I'm talking this is as per the law. Even though the resale is taking place, is actually taking place without authority of law. The property title now continues to be in the name of promoter or a builder. The title of the property holder is liable to pay the tax. To have ownership of the apartment, one has to obtain the joint conveyance for a joint tenancy to make apartment as a property to be heritable and transferable. Local bodies act of issuing KHATA for individual apartment has led to non-conveyance of the title for a joint tenancy. Local bodies are collecting tax on super built area, that too on par with independent houses without offering any service. Local bodies are collecting more tax from an individual apartment holder. Now let us compare how the taxes are being given. Many of the things in a multi-dwelling apartment under the KMC Act is called as a bulk producer of garbages. So bulk producer of garbages, they are supposed to take care of their own interest and their own mechanism to dispose it of. Friends, when they are collecting from individual apartment to individual KHATA by issuing and they are collecting individually, they are also equally liable to give you all the civic services they are giving to an independent house. So here the question comes is, we should insist the local body when I'm having an individual khata to offer me all those service, or every apartment owner should stop payment of property tax, insist local body to collect it from the khata or title of the land. Now, who is liable to pay the tax as per the law? It is a title holder of the land, title holder of the building. So let us insist who is the property owner. So every apartment owner must communicate to the promoter to unable to pay the property tax. The property need to be conveyed for a joint tenancy until such thing let promoter pay the tax. Local bodies need to be questioned for the civic services being not offered to the apartment on par with the individual houses. Why we are suggesting here is, we are paying money, we are paying 15% extra cess to the government, but the same thing is not being offered to us. Now let us understand what are the things that they give. Friends, for a general public, the common area is a road where the people are commuting, and street light taxes, street lights are managed by the local body. Gutter, drainage, everything is being managed. Road is being managed by them. In an apartment, when it comes, if they are making me independent khata, what are the common areas for me? Approach road. My corridor is also a common road because it is accessible by everyone. So all these parameters, now having made an individual khata, individual apartment is a responsible body to maintain the building. This is what, as a home buyers, we should insist. If they are not giving it, then obviously, who is the owner of the property? That is, the landowner or the building owner becomes liable to pay. Let them collect from them. Is a contention that we should take. And secondly, if apartment owner, so many parameters, so many things that we are in, since we don't know, we have not exercised basically the regulatory laws. This is where the problem that we are facing. Unless Section 11 of Karnataka Ownership Flat Act, unless Section 17 of real estate regulatory laws are being implemented properly, your apartment cannot be called as a property unless or until the joint tenancy is being obtained. The entire building do not enjoy the stature of it is owned jointly by all of you. So when it is not jointly owned, the payment of the tax as per the existing laws, as per this is, it makes it very clear, promoter is, who is the owner of the land is liable to pay tax. Why we should be hurried to go and pay the tax? And if at all today you must have paid some bribe and obtained such certificate, and you are paying tax now. Can you ask them to give all the civic services to us? That is what the people have to think about. So the entire, in summary, I would like to say, unless or until Section 11 of COFA and Section 17 of RERA is complied with, apartment complex, an individual apartment cannot be called as a property, because as it is not transferred. If it is not transferred jointly, obviously the landowner or the building owner is liable to pay the tax. So let us insist for it. Let us make the local bodies are also responsible for it. And it is in our interest, if at all we want to follow the law properly, then obviously the entire property has to be a joint property with tenancy in common. So if that is being achieved, you all become individual owners, UDS becomes the ownership, and complex becomes the ownership, and you are all joint holder of the property unless or until we achieve Section 11 and Section 17 compliance to the law. So with this, my discussion comes to an end on this property. tax. The property tax in a nutshell as of date, the payment of property tax remains remains on the promoter, and the local bodies can only collect the tax on the entire building. No chance to give to collect the tax from the portion of the building, and no law permits them to collect it. But we are only making in a hurry. We want our property tax, so we are going ahead with this. Please try to ask a question to the local body on what basis and where are the laws for them to issue the KHATA. When you are not the ownership or the property is not jointly conveyed to all of you, and which law permits them to issue a KHATA for a portion of the building for which they are asking you to pay the tax. So with this, my discussion comes to an end. I thank you very much, all of you, for patiently hearing. Any questions that you have got, you can ask me. I would be very delighted to resolve your doubts that you are having. Thank you for giving me an opportunity for me to express my ideas and how to, as a home buyer, how we should protect our interest. Thank you, everyone.
Thank you, Anil.
Thank you.
Thank you very much for this enlightening session.